now we're going to go south to our brothers and sisters in Poland. I would like to invite Dr. Jakub Urbanik, who is going to be talking in the theme of respect for human dignity, equality, respect for human rights, including the rights of persons belonging to minorities. Words, words, words. The Union and LGBTIQ+Rights. Dr. Jakub Urbanik is a law historian specializing in legal awareness in antiquity and legal tradition of marriage and family in the past and modern era. Professor of the Faculty of Law and Administration of the University of Warsaw, head of the chair Roman Law and the Law of Antiquity. Here we are.
Thank you so much. I'm deeply moved to be able to speak here today. So I'd like to give thanks first of all to the Minister of Justice. It's a rare occasion that one can actually speak at the Ministry of Justice in our region on LGBTQ families. And thank you so much. I think this is not my presentation, but the one that is coming afterwards. So, I can do both. So I'll try to be very brief, which is difficult. But as you have noticed, my topic is taken from the act we all know and we all aspire to respect. And I'd like to have a very brief look at what would be the standing of the Union versus the LGBTQ rights and what would be the standing of the national states versus the rights via the Union. So first of all, a quick and rhetorical question, whether it's a bottom-up or top-down approach, then the premises of the Union, and then the 6 outcasts, as I'd like to call us, taking Poland as a test case, because I know it best, and it's also a very problematic case, as you all are aware, mostly because of the constitutional crisis and the judicial crisis lately. Finally, a small conclusion part, whether it's more about legal tools or policy strategies, and the possibility of a backlash, which is indeed happening in Poland partially. So the Union premises are easy, so to speak. But actually, the only horizontal act of the Union law is the well-known Council Directive of 2000, which mentions openly, expressively, sexual orientation as such. And this is very important also for what Milena is going to speak about later, because this is the only act that has been translated directly into our national law, into Latvian national law, and I am afraid that it's only due to the pressure from the Union that we were aspiring to join, not because of our willingness. Of course, we've got the Charter of Fundamental Rights, and we've got parliamentary resolutions and Commission policy statements. But they are, in a way, soft law to a certain extent, if they are law at all. Of course, not the Charter, but then, again, as you know, in Poland, the Charter has been doubted, whether it has got any legal force nowadays. The Union premises from the judicial part, the courts. I'm, of course, completely aware that the European Court of Human Rights is not part of the European Union, but of course we know the mutual trust and cooperation between the Strasbourg and Luxembourg courts, so I need to mention that. I will not read out the cases, you know them all. There are very few cases of the Court of Justice, for obvious reasons. There is a very limited application of the Union law for the family matter, so it really takes a struggle to take them to the courts. And also because there needs to be an initiative of the nation state or the national courts. And again, I'll come back to that in a moment while describing the situation in Poland. So the Court of Justice will not act out of its own initiative. Yet, there are some signs of hope, and especially the still pending case of VMA and Stoliczna Obsztyna with the opinion of Advocate General Kokot gives a lot of hope for the future developments. Now, to a brief overview as Poland as the test case. Kaspar has already shown it beautifully. There are none. But I'd say we are in a worse situation. We've discussed it with Her Excellency the Minister today in the morning. We are kind of the troublemaker among the six. And it could be worse, say the Lithuanians or say the Latvians, for instance. It could be as it is in Poland. Or Hungary, for that matter. So the Polish constitution has got a usual article on equality. It's the Article 32. It does not mention a sexual orientation at all. It doesn't have to, because it speaks of all grounds of discrimination. On the other hand, we know that some constitutions, and now possibly Kaspar's presentation with the Netherlands of 2021 is not that such a mistake, because it's being processed to introduce the final amendment into the Kingdom of Netherlands constitution to include the sexual orientation as a prohibitory ground of discrimination. Of course, we know as lawyers that words make difference. It's words that create reality. And if we name phenomena, then we observe them and we can counteract against them. As I've said, the only direct translation of that article is the Polish Labour Code for prohibiting discrimination in the labour relations. But then again, it's not thanks to the Constitution, it's thanks to the directive, I'm afraid. And then we've got the Article 18 of the Constitution, which the Polish official same translation reads on the marriage as a union, marriage being a union, of a man and a woman, as well as the family, motherhood, parenthood, and so on, shall be placed under protection care of the Republic of Poland. I would not agree with my distinguished colleague before that it actually defines marriage as a only heterosexual union, because it's an example. Though, that's my quick mistake from a moment before, the official translation has it as being, and thus most of the scholarship, and some of the courts as well, or most of the courts, read it as a legal definition of marriage, not only excluding same-sex marriage, but also in some cases, people say, excluding any other kind of formalization of same-sex unions, which, again, I think is completely wrong, but that's a topic for a different paper. The Polish courts, then. If there is no statutory law, there is a room open for what Jan Hirsch in 2004 defined as juristocracy, judicial activism. And the seminal book of Hirsch has been followed by a number of seminal decisions of both national and pan-national courts, proving his topic right, his thesis right. Courts do take part, active part, in creating the civic society, in creation equality. And just to mention one in your presence, Ambassador Oberwecher and Hodges is the groundbreaking solution here. What about the Polish courts? They have not been so activist. I don't have time to explain it in detail, but basically only the right to assembly, and in the previous still valid constitutional tribunal has been fairly and firmly secured. There is a bit of closeness of person, so in Poland it is actually corruptive to have same-sex partner. We do have that in criminal law, thanks to a resolution of the Supreme Court. But there is very little about hate speech and transphobia. Actually, the result is negative. Same-sex parenthood, just 2 judgments of the Supreme Administrative Court, positive, but then a very negative resolution of the court stating that you cannot transcribe foreign documents into the Polish legal system. Yet, this is important, most recently, for the very first time in our history, administrative court has posed a preliminary referral to the Court of Justice in a case very similar to the Bulgarian one. So we hope it will be finally settled and maybe it will be applied in Poland. Marriage alike, nothing there. But then my final point, LGBT ideology-free zones. You know it all, I will not explain it in detail. An action taken mostly thanks to the former Commission of Human Rights, Adam Bodnar. Milena was working on his team back then, challenged these resolutions, and some of them have been invalidated by the courts. It's a difficult legal problem, actually, but I will not come into detail. But what is important in these judgments, especially in the administrative court in Gliwice, is that the court goes way beyond what we had been expecting. It goes on human dignity, and it settles well what are the limits of public authority in Poland. So again, are courts to come to our avail? Yes, sometimes, but actually there is very little done. First of all, because there is a limited application of the European judgments in the courts in Poland. Strangely enough, they don't read these judgments, they don't cite them, or they cite them wrongly. And secondly, because there is this, apart from this one single case, there is an unwillingness to refer cases to the Court of Justice. Sorry. So, what's there? The recent years, as you know, have been marked by a rise of homophobia, transphobia, biphobia in Poland, used as a political tool. It's a red flag. It can always be worse. It can always be worse, even if the countries in which the situation seems to be fairly well stabilized. But there is a little green light of hope, namely the fact of the Polish constitutional crisis and the court crisis. The courts have been under pressure. The courts have been attacked. Again, I have not tried to develop that, but I think that the judges themselves have found how it is to be a minority, a repressed minority, a black-faced minority in public media. And maybe that's why they found a little bit of sympathy and empathy for us. But then again, what really matters, as it seems, are not the legal tools. It's the money. It's the money. Money makes the world go round. It's not the valors. It's the threat of the European Commission to withdraw the funds that have pressed for withdrawal of some of these infamous declarations. In the last couple of days, there have been a number of those withdrawals. And let me just mention one. The Województwo Podkarpackie, the bastion of ultra-right-wing voters, originally had this resolution against promotion and affirmation of the ideology of the so-called LGBT movements. In the last couple of days, they have a declaration stating that Podkarpacie is a region of firmly secured tolerance. Valors? Law? No. Money pressure. So, what I would like to perhaps conclude with is that as a lawyer, I have a great hope in law. Law as a social tool of change. But that's not enough. We need strong policy support. For now on, there seems to be a strong policy support from the Union, from the Commission, especially from the Parliament. But how long will it last? As long as the voters will be in favor, I'm not afraid. I'm afraid to say. And then again, there is a possibility of a backlash. I'm so happy that Her Excellency has received us today at the Ministry. Our Minister of Justice has been tweeting constantly, it's better to be out of the Union than have rainbow families or rainbow marriages. Let me just hope that the good will take over, and that Commission will firmly take the steps to protect us further, to protect our rights, which are nothing else but human rights. And I suppose it's the moment for Milena now to speak about the recommendations.